Your original hometown dealer, Saida, Trudeau Chrysler Jeep Dodge and Ram.
18-year-old Nevaeh Miller appeared in front of Justice of Peace Michael Foley in court today for the extension of her preliminary hearing, which turned out to be a waiver of the preliminary hearing according to District Attorney Keith Brower, where she pled guilty to a charge of simple battery stemming from an original incident involving her grandmother.
As a condition of the plea or part of that negotiation today, she's pleading guilty in 25 CR 01485 to a misdemeanor battery for the battery against her grandmother. The adjudication in that case is stayed. However, we're asking that you impose a 180-day sentence suspended to start today. Judge, you are allowed to hear from the grandparents as speakers.
Miller had then been held in custody on a separate felony charge of attempted deterrence, which alleges that she interfered with or attempted to obstruct a legal process. Following today's developments, she was released on her own recognizance and is scheduled to return in district court on September 18th, 2025.
She'll bind over to district court on the charge. In district court, we anticipate that she'll enter a plea to one count of an attempt for the harbor and conceal aid, the felony offender. The state, at that point in time for sentencing, both parties will recommend that she receive probation. That one of the conditions of probation that she receive is ongoing mental health counseling. She'll have all the other conditions of probation. If she successfully completes probation, she'll be allowed to withdraw that plea and receive a misdemeanor disorderly conduct with credit for time served.
During the hearing, Miller pled guilty to the battery charge involving a domestic incident with her grandmother. The court accepted the charge and sentenced her to 1 year of supervised probation with a 180-day suspended sentence, effective immediately. She was not remanded and was allowed to leave the courtroom under specific conditions. Although Miller has not entered a plea on the attempted deterrence charge, both the prosecution and defense indicated that a resolution is being negotiated. As part of that anticipated agreement, the Category D felony charge is expected to be reduced to a misdemeanor, and Miller will enter an Alford plea. An Alford plea allows a defendant to maintain innocence while acknowledging that the evidence presented by the prosecution could likely result in a conviction. If a plea deal proceeds as expected, Miller will face up to 3 years of supervised probation, a reduction of the attempted deterrence charge to a misdemeanor for good behavior, and no contact order with the Perry family. While out on her own recognizance, Miller must comply with court-imposed conditions including following all terms of her current probation, complying with any restrictions or future rulings set by the district court, avoiding and refraining from making contact with the Perry family. Miller is due back in district court on September 18th, 2025, where the court will determine whether to accept the proposed plea agreement and finalize sentencing for the attempted deterrence charge.